When Lionel asked me to speak, March seemed like a really long way away, and I was very confident that the Trunky decision would have come out ages ago, long before I'd be standing here. I hadn't banked on just 3 days to think about it, but at least the judgment came out on Wednesday and not yesterday. So I'm going to talk about interpreting designs, and in that regard, the Trunky decision time is very suitable. And if my timing doesn't go completely awry, I've got something to say about the recent amendment to the definition of design for UK unregistered design right, really because Lionel asked me a question about it. So Trunky, I've enjoyed reading the commentaries, and I've popped a selection of quotes up there on the slide. The judgment is apparently going to have profound implications. It's going to serve as a rude wake-up call. The judgment is a travesty and plunges design law into an abyss. And Rob Law's case, he's devastated and bewildered, and perhaps in his reaction is understandable, because he's the designer, and he's ended up coming second in this particular contest. And given that in the Supreme Court judgment, the court expressly states that the design had been both original and clever, a significant commercial success, it was clear that the defendant company had come up with the idea of the kiddie case, having seen the Trunky, and decided to offer a disco version of it. You can understand why Rob Laws is upset. So what's the fuss about? And here they are. I get to use pictures because it's designs. Magmatic manufacture and sell this well-known Trunky children's ride-on suitcase, shown on the top left. And the registered community design there in the middle was a grayscale CAD drawing. And you can see the contours by shades of grey, and the strap and the central strip and the wheels are there in black, or at least in contrasting shades or different shades of grey. An example of the PMS product, the kiddie case, is at the bottom. And I've also included in the slide on the right the most significant piece of prior art, the rodeo. And at first instance, Mr. Justice Arnold held that this is clearly a shape registration. Whilst it was itself an evolution of the award-winning rodeo, a design from a few years before from the same designer, it was novel over that prior design. It had individual character over the design corpus, consisting of clamshell suitcases for adults and not including the rodeo. It was a significant departure from the design corpus. It deserved a broad scope of protection, and the kiddie case came too close. And permission to appeal was given essentially on just the one issue: whether, when making the assessment of the overall impression created by the kiddie case, the court should take into account the graphical designs printed on the surfaces of the case, the surface decoration, or whether it should only take into account the features of shape of the kiddie case. And if surface decoration is to be taken into consideration, where the kiddie case do not produce on the informed user a different overall impression. In other words, if I've correctly understood, it was acknowledged by the trial judge that if he was wrong about this being a shape design, then the presence of the surface decoration on the kiddie case might make a difference to the outcome. And I suspect anyone interested in design knows the Court of Appeal overturned that first instance decision for reasons we will look at, and so continued its unbroken run of not finding infringement for community design. And the Supreme Court has just upheld that Court of Appeal decision. So the kiddie case, developed as a discount version of the award-winning Trunky, does not infringe what was undoubtedly an innovative design, held to be entitled to a broad scope of protection. So what happened in Trunky? Deciding infringement in a registered design case must surely consist of two steps. First, identify the design which is protected, and then consider the overall impression of the design which is protected against that of the accused product. And when making that comparison, it's a like-for-like test. So if the design is for shape alone, you only consider the shape of the accused product. If it's for surface decoration, you consider only the surface decoration, and so on. And incidentally, in Trunky, the like-for-like test was specifically accepted by both sides as the correct test. In Trunky, the Supreme Court considered these three aspects. They considered first, shape, second, did the design claim a positive absence of surface decoration? And third, colour contrast, especially between the wheels and the body. And the Supreme Court reminds us that an appellate court should be slow to interfere with the judgment of a trial judge, quoting Lord Hoffman in Designers Guild, who said, because a decision involves the application of a not altogether precise legal standard to a combination of features of varying importance, an appellate court should not reverse a judge's decision unless he's erred in principle. But I don't think anyone would dispute that Mr. Justice Arnold, who's our chair today, is not a novice in the field of designs. And we know, as a result of that first instance judgment, that if only shape is considered, there is infringement, because that's what Mr. Justice Arnold decided at first instance. Okay, so far, so good. So let's look at the criticisms. This is not in the order that they deal with them. One error the Court of Appeal identified was said to be that judge ignored the colour contrast in the registration between the body and the wheels. Lord Justice Kitchen considered the design was not just shape, it was at least shaped with these tonal contrasts, shown by the wheels and the strap being black, or at least different tones of grey. And the Supreme Court agreed with that. Now, whether that alone should have made any difference to the outcome, I think is questionable. As a question of fact, the wheels on the kiddie case are black, and they are also mainly covered. And Mr. Justice Arnold knew that when he made his assessment of overall impression. He said something about it. So I'm not convinced that the appearance of the wheels was ever the tipping point so far as overall impression was concerned. It was also said that the judge failed to give proper weight to the overall impression of the registration as an animal with horns, and failed to take into account the effect of the lack of ornamentation on the surfaces of the images in the registration. Whilst the Supreme Court has dealt with these as 2 points in this way, they're not on the slide, I'm not at all sure that they are 2 points. I actually think if you read the Court of Appeal judgment carefully, they are inextricably linked. Dealing with the first one, the Court of Appeal said the judge had failed to appreciate that this is a design for a suitcase which, considered as a whole, looks like a horned animal. But it's clear from the first instance decision that the judge had expressly stated that the ridge and the horns form an important part of the design's appearance. Furthermore, the clasps look much more like the nose and tail of an animal, and the clasp on the front being under the horns gave the impression of animal characteristics. And the judge identified the feature of 2 handles at the front, shaped like horns, as a feature which was novel over the design corpus and present in the kiddie case, albeit different in shape as an antennae or as ears. And in the judge's comparison for infringement purposes, he expressly stated, if it was not for the rodeo, I would have little hesitation in saying that the kiddie case produced the same overall impression on the informed user, having regard to the broad scope of protection to which the design would otherwise be entitled. And he went on, despite the differences between the kiddie case and the design, the overall impression the kiddie case creates shares the appearance and horns, horn-like handles and clasps looking like the nose and tail of an animal, which are present in the design and absent from the rodeo. So I think it's clear the judge did take this aspect of the design into consideration on the basis of his assessment of the shape of the design. And it seems that the Supreme Court is saying, because the judge didn't expressly state that the overall impression was that of a horned animal, he'd failed to take that into account. But in light of these things, these quotes I've just given you, if you squint at that proposition, you look at it sideways with your eyes half closed, that might be logically plausible, but it is obviously wrong. The Supreme Court goes on to look at whether the surface decoration of the kiddie case should be taken into consideration when considering the scope of protection. And here's the missed opportunity, because the Supreme Court declines to decide whether the absence of surface decoration is a feature of the design or not. In Procter & Gamble, the court never questioned that these monochrome line drawings were protecting the shape or contours of the product. And the comparison that was made was between the line drawings and the alleged infringement with the surface decoration on the alleged infringement blanked out. The same thing happened in Dyson and Vax. The representations in the registration were photographs, and the alleged infringement was painted grey for the case so that the comparison was like for like. In Samsung and Apple, these line drawings in the High Court were treated on the basis that they covered the design of a particular shape and issue with a positive absence of surface decoration or ornamentation. But in contrast, in the validity decision in OHIM, in respect of this same design, the tribunal seems to have come to the opposite conclusion, saying that it's understood from the registration that the front of the device is formed by a screen and protection is sought solely for the shape of the device and the reflective surface. And when looking at prior designs, a like-for-like comparison would be made, confined to shape and surface. But in Trunky, the representations of the design are CAD drawings, not line drawings. And in Lord Neuberger's view, a line drawing, he says, is much more likely to be interpreted as not excluding ornamentation than a CAD image. Doesn't really tell us why. Lord Justice Kitchen expressly stated that it would, in his opinion, be wrong to eliminate the decoration on the kiddie case from consideration entirely, because it significantly affects how the shape itself strikes the eye and the overall impression that it gives. In the case of this design, the global comparison necessarily requires account to be taken of the context in which the accused shape appears. So the Court of Appeal thought the surface decoration was a significant factor. And the Supreme Court seems to have thought here that Lord Justice Kitchen was saying that the shapes alone were different. But he did not do so. What he said was that the shapes in the context of the absence of surface decoration on the design and its presence in the kiddie case were different. Well, I don't think there's ever been any doubt that can be a bona fide difference of view on whether, if you just look at shape, the shape of the kiddie case is too close. The question the court was being asked to consider on appeal was whether these CAD drawings claim an absence of surface decoration, and for that 2 points arise. First, is it possible to claim an absence of surface decoration? And the answer to that is binary, yes or no. But the second point is, how do you show it? And the Supreme Court have simply ducked it. The court says anything they say on this topic is obiter, which I find rather surprising, given that the question whether or not you had to take account of the surface decoration of the kiddie case was exactly the question on which permission to appeal had been given. But the Supreme Court considered that it was unnecessary for them to deal with this question, and the judge said he'd prefer to leave it open. He goes on to say, it's not as if the decision whether the absence of ornamentation in this particular design would be of much assistance in other cases. That's despite the fact that Magmatic and the UK IPO were asking the Supreme Court to send a reference to the CJEU on this precise point. Indeed, at the Supreme Court hearing, I'm told that there were a host of UK IPO hearing officers at the back of the court listening to the proceedings because this point is of such importance. They're handling designs all the time, and they need to understand how to interpret them. So although the Supreme Court specifically declined to decide whether the Trunky design positively claimed an absence of surface decoration, I think the Supreme Court had to decide that, had to look at that issue, because the surface decoration question formed an essential element in the reasoning of the Court of Appeal. You can't make a like-for-like comparison between the design and the alleged infringement unless you have first decided exactly what the registered design covers. But this is precisely what the Supreme Court has done. Moreover, Lord Neuberger added that whilst it might be of little comfort to Magmatic, he said, he thought he would reach the same conclusion as the Court of Appeal. But it's a bit of a mystery to me what Lord Neuberger has taken into consideration when he makes that comparison. So the Supreme Court decides, obiter, that as a point of principle absence of ornamentation can be a feature of a community registered design and makes no attempt to explain how to do so. And why do we care? We care because we are supposed to be able to tell what the registration is for by looking at the pictures. Because we're told that the representation of the design must consist of a graphic or photographic reproduction of the design in black and white or in colour, but that no explanatory text, wording, symbols, other than the indication top for orientation, can be displayed. And I can remember a big fuss about the Designs Directive, in contrast to our old registered designs law, was that it protected designs per se, rather than the article to which a design has been applied. But when we make an application for a design, in addition to the representations, we have to give an indication of the products to which it's intended to be applied. And an application can also contain a 200-word description. And at the time of the Green Paper, it was acknowledged that sometimes there might be a need to explain the features which constitute the design, and which might not easily be perceived simply by looking at the reproduction. This should be made possible by joining a description to the application, we were told. But of course, when the moment came to avoid translation costs, Article 36 states that the indication of product and any description shall not affect the scope of protection of the design as such. So you would think that it should be possible to obtain a single registration for a design covering lots of different types of products. But as a matter of practice, it isn't. When you apply for a design, the indication of products that you give must be classified in only one Meccano class. So if you might use your design on more than one product type, that's going to mean more than one design registration and, of course, more than one fee. So any suggestion that we protect designs in the abstract is mistaken, because we don't. And an illustration of what we do in practice is this case, I call it Gimmicks. I don't think that's how you're supposed to pronounce it, actually. The major dispute between the parties was about the overall impression the designs produced on the informed user. Mr. Justice Birth acknowledged that a key part of the debate was about the correct definition of the product and a connected argument about the design corpus. So the judge had to decide what the product was. He looked at the indication of product and he said that was the right place to start. Then, by looking at the representations in the design, you could see that the bag clearly contains a wine bottle, ice and water, and it's an ice bucket bag. And he decided to define the product somewhat broader as a bottle chiller. Having done so, the court was then in a position to consider the design corpus through the eyes of an informed user. Now, I think the Apple design also illustrates that designs don't exist in a vacuum. Arguably, we know that the representations in the Apple registration we looked at a few minutes ago, we know they're a tablet because the proprietor of the design is Apple. The designers are what they call Jonathan Ivins and Steve Jobs. I get those the right way around? Yes, I did. We know the design is being deployed against a Samsung tablet computer. We've seen iPads in the market. And the indication of the products on the design tells us it's a handheld computer. So you can't ignore the context, and in practice the court does look at the context when it's interpreting the designs. It's not entirely clear to me that the Supreme Court properly understood this. Lord Neuberger said lots of things. He said it's of course up to an applicant as to what features he includes in his design application. He can make an application based on all or any of the lines, contours, colours, shape, texture, materials, ornamentation of the product in question. He can make a large number of different applications which are cheap and simple to make. He can choose the level of generality at which his design is to be considered, and the extent of protection afforded by a design must ultimately depend on the proper interpretation of the registration at issue, in particular the images. And he said that an applicant should appreciate that it will almost always be those images which exclusively identify the nature and extent of the monopoly which he is claiming. And if he wishes to disclaim something, he can do so. He can dotted lines, certain things. And Lord Neuberger says that it's for an applicant to make clear what is included and what is excluded in a registered design. And he's got wide freedom as to the means he chooses. Mysteriously, he adds this: it's not the task of the court to advise the applicant how it is to be done. That's a matter of practice rather than law, and if further guidance is needed, it can be sought from OHIM. So I have to admit that I find that a rather surprising statement. What approach you take to interpreting a drawing for a visual right is surely a matter of law. And I find it surprising that the court doesn't consider it necessary or appropriate, having got to this stage, to ask the CJEU for guidance. The Lord Neuberger thought there was no need to do so, because what they were likely to say is that the images should be interpreted by reference to how they would appear to the reader in the light of the terms of the design regulation, the implementing regulation, and the practice of OHIM. The Supreme Court seems to have missed the fact that there isn't agreement between the courts of member states, even as to who the reader is. At least two appellate courts, in Dusseldorf and the Netherlands, considered the design to be interpreted through the eyes of the informed user. And I'm not sure that all courts would agree with that. Lord Neuberger's confidence in OHIM is touching, but possibly misplaced. Remember IP Translator? The CJEU reference revealed that OHIM practice had been incorrect. And I'm troubled by the court's suggestion that you determine scope solely by reference to what's been shown in the images. That can't be right. Apart from anything else, Article 10 of the regulation tells us that in assessing the scope of protection, the degree of freedom of the designer in developing his design shall be taken into consideration. The degree of design freedom is not something you can get out of the images. And the paucity of information available from the images in the design registration is problematic in other ways too. Let's consider for a minute the exclusion for designs dictated solely by technical function. We know that if an entire design is dictated solely by technical function, it's not registrable. In this Lindner case, these are cutters for a dirty, great big industrial shredder for paper, card, plastic, glass, and the like, for a recycling machine like those shown on the slide. And these machines were used by companies in the recycling business. This was not a consumer product. And the cutters consisted of metal cylinders with knives attached. And the tribunal was invited to consider various essential features of the design. The V-shaped blades, arranged in parallel lines, some on the ridges, some in the grooves, all on the surface of the cylinder. The OHIM Board of Appeal acknowledged that good design involves two fundamental elements. The product must perform its function and it should be pleasant to look at. And for most products, the designer is concerned with both functional and aesthetic elements, but so long as functionality is not the only factor, the design is eligible for protection. It's only when aesthetics are totally irrelevant, in the sense that no one cares whether the product looks good, bad or ugly, and all that matters is that it functions well, then there's no protection under designs law. But this Lindner case was an example of an entire design being invalidated because no aspect of it was determined by any aesthetic considerations at all. But what do you do in a case where a design includes a feature which is solely dictated by technical function? So far as I'm aware, none of the infringement cases so far have had to consider that point. Of course, we know that recital 10 to the regulation says the features of a design which are excluded from protection for being solely dictated by technical function should not be taken into consideration for the purposes of assessing whether other features of the design fulfil the requirements for protection. But does that mean to pretend such a feature is not there at all? And in any event, the regulation says nothing about what you're supposed to do with those features when you come to consider the scope of protection from an infringement point of view. After all, unless the whole design is dictated solely by technical function, it's registrable. So what is its scope of protection? Personally, I don't believe a portion of the design, the appearance of which is solely dictated by function, should be ignored entirely for the purposes of either validity or infringement. It's possible that a design will incorporate solely functional features, but the selection of those specific designs from the available options, or the way in which they are arranged or incorporated into the design as a whole, may have been chosen for non-functional reasons and may affect the overall impression created by the design. But in all of this, we still need to know what the product is in order to know whether or not a feature is dictated solely by function, because implying a function means that a designation of product type is required. If you produce a picture frame to be hung on a wall to the exact design of a well-known tablet computer, the functional requirements are different from those of the tablet, but the visual representations of the design might be the same. So the scope of protection for registered designs is limited in a practical sense by the functionality assigned to its product type. And whilst we're told that an indication of goods is apparently not limiting on the scope of protection, in Lindner, I told you that those cutters were for great big industrial shredder for paper, card, plastic, glass, for recycling. I've told you that the cutters consist of metal cylinders with knives attached. I challenge anyone to get that out of the registration. It didn't come from the registration. It came from the evidence that was brought before the tribunal. Again, the Supreme Court's confidence that you know what design is claimed from the representations in the registration is touching, but wrong. We have classes of goods and services in trademark registrations affecting the scope of protection. We have claims in patents and specifications which accompany the drawings. We should have been allowed to have descriptions explaining the designs claimed in the community regime, but we don't. The failure to send a reference to the CJEU is undoubtedly a missed opportunity. And what does it mean? Is it all doom and gloom, as some of those commentators suggest? If Trunky just taught us anything at all, it's what registered in the first place really, really matters. And legal advice on that is a really good idea. And it means that unregistered community design doesn't last long enough if we want to protect innovation. Because if community unregistered design right had still subsisted at the time the kiddie case came on the market, this would have been an infringement. There would have been a product-to-product comparison. So to my last point? Yeah. And that leads me on to my last point. Lionel asked me whether I thought the amendment to the definition of a design for the purpose of UK unregistered design right, or UK UDR, by removing those words any aspect of, had had any effect on pleading drafting practice. Now, everyone knows the definition of design for the purposes of UK UDR has always been any aspect of the shape or configuration, whether internal or external, for the whole or part of an article. Those words, any aspect of, have been removed from the definition as a result of the IP Act, which came into force on the 1st of October 2014. Now, leaving aside from the question of whether they've been removed retrospectively or not, the question does arise to what extent deleting those words, any aspect of, is going to make any difference going forward. This is because, even when those words are gone, the definition of design remains the shape or configuration, whether internal or external, of the whole or part of an article. And that begs the question, if we can still claim the design in part of an article, what did those words, any aspect of, ever mean or add? And arguably deleting those words not going to make any difference at all. But His Honour Judge Haken has said in the Superdry case that it would be contrary to the usual words of statutory construction if deleting the words made no difference. So we wondered whether it might mean that we can no longer define the design by describing the design as the whole of something minus a particular part not copied. but I don't think it's that. I think it's more likely that the scope of design has been cut down in some way, perhaps so we can't combine two parts of an article which are not connected to each other. So a combination of disembodied aspects cannot constitute a design. You could get protection for all or for part, but not for this bit with that bit. And I think there are indications in the Superdry case that that might be right. Given its impact isn't immediately clear, you would think it would be interesting to look at the government's response to the consultation which led to the IP bill to give us a hint as to what they thought they were doing. The complaint the UK IPO was considering was apparently that proprietors can easily establish that a new and competing design infringes theirs by basing a claim on a very small or cropped part of an article. In this way, they can say that another design article infringes theirs even when the overall appearance of that article is not very similar at all. But the government acknowledged that a small majority of respondents did not agree that the definition was flawed in any way. Instead, it gave businesses flexibility. And there was no evidence that UK unregistered design rights had been used to prevent others from establishing new designs. At which point you might think the government would refrain from fiddling with it. But the fact that a specific scope of design did not need to be elucidated until it was enforced was identified as a problem, apparently placing a considerable burden on defendants who don't know the precise nature of the right until the case is pleaded. And the government's compromise is to delete any aspect of, they say, to reduce the tendency to overstate the breadth of UK unregistered design right and the uncertainty it promotes. Now, there are commentators who say UK unregistered design right is not needed, that we have a community design regime, that community registrations are cheap to obtain, and we have community unregistered rights. But we have a community unregistered right which lasts only 3 years. And the Trunky case has perhaps illustrated some of the problems which arise from the lack of opportunity to explain what you're trying to claim at the time you file your registration. In contrast, unregistered design rights are flexible. A business only needs to define the right it claims at the time the infringement is known. And while some people seem to think that's unfair and make it difficult for defendants to know where they stand, at the end of the day, unregistered designs only protect against copying. If a defendant hasn't copied, then he's got nothing to worry about. So do I think deletion of the words any aspect of make any difference to pleading practice? No. We're still going to claim the whole of an article. And then we're going to claim the whole of an article plus minus some feature that was not copied. And then we'll claim various copied parts. And we may well claim some permutation or combination of those things until we're told we're not allowed to, or unless we do a particular combination that we're told we can't do. And that reason has got nothing to do with whether the words any aspect of appear in the definition of design. The reason is instead because the test of infringement in the case of UK unregistered design right is not the overall appearance of a product. And I guess it's a bit of a surprise that those words crept into the government's response to the consultation on this. Instead, the test for infringement is whether the alleged infringement is made exactly or substantially to the design. And in those circumstances, if a claimant isn't free to define his design in that way, he won't get home on infringement. Sorry, I've run